we do, all right, I'm just recording the meeting, and we do have another one booked for the beginning of December. So hopefully before the Christmas mayhem starts, we will have another instalment for you. And today I'm joined by my colleagues, Jeremy and Neha. They work primarily from our London office, and they're also going to be speaking today. Jeremy's going to start with a reminder, really, and a couple of cases about restrictive covenants and security of information, particularly in the new world that we find ourselves working in, which really is likely to remain a hybrid arrangement, and some of the considerations that employers might want to think about in relation to that. I'm going to cover the statutory defense in discrimination claims and a new case called Galen about that defense and whether or not and why not the employer could rely on it. And Neha then is going to finish up by talking a little bit about the recent government consultation on flexible working, particularly in relation to women and how they generally are the employees who most frequently request flexible working due to childcare reasons. There's been a recent case that Neha will cover in relation to that. And she'll also talk about another recent case called Bayfield, where the employer in that case took an overly zealous approach to trying to eliminate their gender pay gap in a redundancy situation. So hopefully that gives you a flavour of what you're going to listen to this morning. We won't go on for too long. We know it's different listening to a webinar rather than a face-to-face seminar. So we will hopefully be finished talking in about 40 to 45 minutes. And then if you've got any questions, if you want to type them out into the question and answer section, then we will do our best to retrieve them and answer them for you at the end. So without further ado, I will hand over to Jeremy.
Well, thank you, Natalie. Good morning, everybody, and welcome to the webinar. I'm going to hide my self view now, so I can't see myself, which is always a benefit. So in terms of looking at the situation that many employers find themselves in, with employees working a little bit at home, a little bit in the office, and so on and so forth, and the impact that has on confidential information and restrictive covenants, it's worthwhile setting the scene a little bit in the context of the implied terms that exist when people are employed. And we call that the duty of fidelity. And whilst people are employed, there are strong implied terms which prevent staff from misusing their employer's confidential information and making secret profits. Now, of course, many employers augment the implied term with express contractual provisions. And that is particularly important in the context of what happens after employment. Because after employment, with one exception, employees are generally free to do what they want to do as regards confidential information and so on, in the absence of express contractual provisions. And the one thing that staff are not supposed to do is misuse employers' trade secrets. Now, and this is the implied term. Now, trade secrets is a very specific category of information. When I started out in this field, we always said that the recipe for the coating of KFC chicken would probably amount to a trade secret. And now we might say that the algorithms that Facebook and other web-based companies use, it's those algorithms that might amount to a trade secret. So it's only trade secrets that can be protected in the absence of express clauses. Now, of course, what we do see are many employers imposing on staff enhanced confidentiality provisions in their contracts, and also restrictive covenants. And restrictive covenants cover things like non-competes, which say you cannot ply your trade for a particular period of time in a particular area. And we also have non-solicitation and non-deal covenants protecting client contacts. And we have non-poach provisions protecting the stability of the workforce by preventing former employees from poaching and stealing the best people. We also know that the restrictive covenants are subject to stringent rules in terms of their enforceability by the courts. These provisions must be reasonable and they must protect a legitimate interest being something like confidential information, client contacts, or the stability of the workforce. Now, in light of the crisis that the world faced in March 2020, the government has launched a review into whether non-compete provisions should be allowed. And that review took place between December 2020 and the end of February 2021. And the government asked for observations in relation to whether or not non-compete provisions should be banned, simply outlawed. I think it's the case that in California, non-compete provisions are unenforceable. So the government looked at that option. And the government also looked at introducing a rule that employers can only enforce a non-compete for a period of time during which they provide compensation, so pay essentially, to the member of staff. Now, we don't yet know what the outcome of that consultation period is. We wait to hear. But what we do know is that in 2016, the government undertook a review in relation to all types of restrictive covenants, so non-solicitation, non-compete, and non-poach. And the general view of those putting forward observations was that the law worked well, everybody understood the law, there were tried and tested principles laid out in cases over the years, and therefore things should stay as they are. So it will be interesting to see whether the 2020-2021 review decides to change things or just keep things as they are. Now, we always advise clients to keep under review their protections in relation to restrictive covenants and confidential information. And of course, we also know that working from home was something that happened pre-March 2020, but since March 2020, a huge swathe of the workforce has been working from home at some points in time, 100% working from home. And now we perhaps find ourselves in a situation where people are working from home and in the office on a split that suits individuals and individual businesses. And of course, when we went into the first lockdown, I doubt that many employers really paid much attention to issues of confidentiality. It was just get the staff at home, get them online, get them working, and hope for the best. Now, employers who were a little bit ahead of the game may well have already had a working from home policy, a policy that, for example, required staff to keep confidential information away from other household members, perhaps required them each evening to put any confidential information into a filing cabinet and so on and so forth, and quite possibly laid out provisions in relation to the disposal of confidential information. Now, not all employers would have had a working from home policy, and now is certainly a good opportunity as these new working patterns of flexible hybrid working become rather more entrenched, to make sure that all of your staff who are working at home for any period of time are observing the correct protocols in relation to confidentiality, particularly perhaps where they're sharing the house with others in their family, or indeed not in their family. Of course, it's also the case that challenges in relation to managing confidential information are exacerbated by the fact that when staff are working at home, you can't observe what they're up to. Because we've all probably been in offices thinking that somebody seems to be away from their desk a lot, having lots of conversations in the stairwell, and that might be a bit of a flag that the employee is thinking of making a move. But now we don't see that to quite the same extent. We're also, of course, trying to deal with issues thrown up by social media. The social media giants have probably had an absolute field day during lockdown. People have still been able to post on LinkedIn and Facebook from home. But these innovations that we've seen in the last 10 or so years do present challenges to employers, because the information that individuals store on social media is portable and available post-employment. It is in the public domain, and there are blurred lines, to say the least, between information that an employer can confidently say is their confidential information, and information which individual employees might regard as their information, and their contacts which might have pre-existed the particular employment that they're in at that time. And the employer's position is not helped either by the fact that many of the terms and conditions that relate to these platforms state that the platform is owned by the individual LinkedIn account holder. So that is not helpful if you're an employer. Now, this is an evolving area of case law, and there are not too many cases in this area, but there are some cases that give us some clues as to the way in which the court may interpret different scenarios. There is a case called Penwell Publishing, and in that case it was ruled that the employer owned the entire contact list of a journalist, and that case, it is said, might have been decided differently if the journalist had carved out his long-term journalistic contacts that he'd accrued over many years in the industry from those contacts which he was trying to essentially steal, which were going to help him set up a new business venture. There is also the case of Whitmar Publications, and in this case, a group of employees had set up a business before they resigned from their current employer, and they had then used contact information on LinkedIn in order to further that business enterprise. Now here, the employee was ordered to hand over their control of their LinkedIn account to their former employer. And this was despite the fact, of course, that the LinkedIn user agreement stipulates that the LinkedIn account is actually owned by the individual themselves. Now, I have certainly worked with clients seeking to impose particular policies on the use of LinkedIn, particularly where the employer is paying for the premium LinkedIn service. And we have said, for example, that unless the employee signs a LinkedIn policy, the employer will not pay for the enhanced LinkedIn premium, and the policy may make a specific number of requirements, in particular the fact that the employee must, at the end of their employment, delete from their LinkedIn account any contact contacts which they added to the LinkedIn account during their tenure with the particular employer. There is also the case that's worth looking at of Hayes Recruitment, where a Mr. Ions had set up a competing business. He searched the database of his former employer, and then he contacted all of those clients on LinkedIn. Now the court ordered him to disclose documents to disclose documents evidencing his use of contacts that he had acquired whilst he worked for Hayes Recruitment. But the court didn't order him to order the disclosure of all of his contacts. That would have gone too far, because all of his contacts, of course, would have predated his employment and would be more general contacts, as we saw in the Penwell publishing case. So another question that exists is in relation to solicitation. It's generally viewed that somebody only breaches a non-solicitation covenant if they actively take a step to contact a client, hit that client up, and it's an active step. So what about just changing your LinkedIn profile, which says, so-and-so now works at Newco? Is that an act of solicitation? Well, the general view is probably not of itself. The mere act of changing on your LinkedIn account the place that you work is probably not an act of solicitation unless it goes further and, for example, invites contacts to get in touch with an individual following as they arrive at their new employer. So that's a very brief canter through some of the challenges that social media presents, the government consultation and so on. But certainly as we look at the new equilibrium in terms of working and people working from home, it's a good opportunity to review your policies and procedures, particularly in relation to working from home, use of social media, and also the provisions that are set out in individual contracts of employment. Particularly, I would say, in the context of new joiners coming into the business, and also in relation to anybody who is going through a promotion. Because if they're going through a promotion and possibly getting a pay rise, it's much easier to persuade them to sign up to new restrictions and so on. So that's all I have to say. Happy to deal with any questions that may emerge going forward. And I will now hand on to my colleague Natalie in relation to the statutory defence in discrimination matters.
Thanks, Jeremy, and thank you for your helpful reminder about some of the various challenges that employers will face in relation to client contacts and information, particularly on those virtual platforms. So moving on to the statutory defence. The reason I wanted to talk about this is because there has been a recent case decision from the EAT. So that's an appellate decision, and it's always quite useful to have decisions at that level because, of course, they set precedents for their decisions. But the background to the statutory defence, before I go into that in more detail, is the principle of vicarious liability, which is probably a phrase that's familiar to most people. And that's really the principle that the employer can be liable for the wrongs committed by an employee where there is sufficient connection between the wrongs and the employee's employment, so that it would be fair to hold the employer liable vicariously. And it doesn't matter that the employer itself has committed no wrong. And of course, this whole principle is policy driven. It's an acceptance that economic activity carries with it the risk of harm to others, and that those responsible for that activity should be liable to anyone suffering from wrongs committed in the course of that enterprise or activity. So imposing strict liability on employers should encourage them to maintain good standards of practice by their employees. And the sort of underlying policy considerations of vicarious liability is that it's reasonable that that liability is borne by the defendant with the means to compensate the victim. And more often than not, that's going to be the employer, because their pockets will be deeper, or they will be insured against those sorts of liabilities. Some of the other considerations are that because the wrongdoing will have been committed as part of the activities being undertaken by the employee on behalf of the employer, and generally speaking, the employer will have had a certain degree of control over the activities of the employee. But this isn't a talk about vicarious liability. That was just a sort of quick reminder of the principle. Where it crops up most frequently in the employment arena is in discrimination claims. And Section 109 of the Equality Act 2010 contains an express provision that's equivalent to vicarious liability, although it is slightly different. At common law, the effect of vicarious liability is to impose a secondary liability for the employee's wrongdoing, whereas under Section 109, it imposes a form of constructed liability in that it deems that the employer itself will have committed the act of discrimination as well as the employed person. So the precise wording of Section 109, for those who aren't familiar, states that anything done by a person, A, in the course of A's employment must be treated as also done by the employer. So, and it also expressly says that it doesn't matter whether or not the act was committed with the employer's knowledge or approval. So it constructs that liability. So what is done by the employee is done by the employer, and they are also liable. The one thing that the Act does require is that the conduct was in the course of employment. So the conduct by A, the employee, was done in the course of his employment with the employer. And as you can imagine, there is copious case law about what constitutes in the course of employment. And suffice to say that it does have a wide meaning. The Equality and Human Rights Commission Employment Statutory Code of Practice offers some guidance on that. And it's quite clear and quite well accepted that in the course of the employment can constitute acts in the workplace, but may also extend to circumstances outside the workplace. So work-related social functions, business trips abroad, while not actually in the office per se, can be deemed to be in the course of employment. So it does mean that employers need to be a little bit careful when arranging social functions or sending people off to other premises or business trips, because anything done on those occasions could attract liability on the part of the employer. But it is always fact sensitive, and it will be considered in light of all the facts of the case and the circumstances. So in the context of Section 109 and this vicarious liability or this constructed liability, what Section 109 gives the employer is the ability to put forward a defence, so that if it can show that it took all reasonable steps to prevent the alleged perpetrator from doing the alleged act of discrimination or something like it, then that is a defence to that liability. And that's what's known as the statutory defence. It was also contained under all the various previous discrimination legislation, or rather words to that effect, but they have been deemed to be sufficiently similar that all the previous case law that chatted about these things remains relevant. And there have been certain principles established under those cases in relation to statutory defence. And what they have said is that the proper approach to looking at whether that can be relied on is to identify whether the employer took any steps at all to prevent the employee doing the acts in question or any acts of that description, and then to go further and consider whether there were any further steps they could have taken that would have been reasonable. So it's almost a two-stage approach. What did they do, and what further could they have done to prevent those acts taking place? And they are clear that an employer is entitled to consider whether the time, effort, and expense of a suggested measure will be disproportionate to the result likely to be achieved. And we'll look at that in the context of this Galen case, and that is around the effectiveness of the steps that were put in place. The focus, of course, is on steps put in place to prevent discrimination. So subsequent events after an act of discrimination are not relevant. So, for example, an employer might say, well, as soon as we discovered the act of discrimination, the harassment or whatever it was, we disciplined the perpetrator. Well, that's a bit after the horse has bolted, but the only way in which it could be taken into account is that subsequent acts, such as disciplining, may shed light on whether an employer merely paid lip service to its equal opportunities policy without implementing it in practice. So if you can show that you acted on your equality or harassment policy and disciplined a perpetrator, then you show good faith and best practice and condoning behaviour. It may not be the be all and end all, but I think it would cast the employer in a better light. In assessing what further steps could reasonably have been taken, an important issue in this is whether the employer had any knowledge of the particular risk that an employee would act in a way that the perpetrator had done. So, for example, if you think of a one-off act of serious sexual assault or sexual harassment, if there was nothing to alert the employer or any other employees that there was that particular risk, then it might be sufficient in putting forward and successfully arguing the statutory defence that there was a sufficiently well-established and well-communicated sexual harassment policy, for example, that made it clear that the conduct in question wouldn't be condoned or encouraged by the employer. However, the position would probably be quite different if there was knowledge or suspicion that that particular employee had some sort of predilection and there was a risk that he might commit that sort of inappropriate act towards other employees. Reasonable steps that the employer might have taken in that case would be not only a well-communicated and well-drafted policy, but also perhaps to subject the suspected perpetrator to closer supervision or warning managers that they ought to be very vigilant. So it is difficult to say from the outset what you should do, although there are some basic minimum things that are pretty obvious, really, that we'll touch upon in a moment. At the very least, particularly the EHRC Code of Practice suggests that reasonable steps would be an equality policy, perhaps also a harassment and bullying policy, equal opportunities, and ensuring that workers are aware of the policy and probably providing training on top of that. Also reviewing the policy as appropriate and dealing effectively with employee complaints is pretty important too, to show that you are acting upon your advice and your policies. So the recent case that I mentioned at the beginning is one called Alley UK Limited and Galen. And this was heard this year in the EAT. So it's a recent appellate decision. Mr. Galen was of Indian origin, and he was dismissed on the 15th of September 2017 for performance-related reasons. He complained that he had been subjected to harassment related to his race by a fellow employee called P, and also that 2 or 3 other employees, 2 of whom were managers, were aware of the conduct but had failed to report it. An internal investigation established that P had indeed made racist comments, and he was ordered to undertake further equality and diversity training. Mr. Galen brought claims against his employer, including one for harassment, and his employer, A Limited, sought to rely on the statutory defence, but this was rejected by the Employment Tribunal, and the complaint of harassment was upheld. The tribunal accepted that the employees had received training that covered harassment related to race, which also included what employees should do if they heard unacceptable remarks. However, what the tribunal noted was that the training had been provided in early 2015 and therefore was clearly stale. And it said that the need to provide refresher training was amply demonstrated by the remarks made by P and the failure of his colleagues to properly react to the harassment. So in this case, the tribunal found that A Limited had failed to establish the reasonable steps defence because of the failure to refresh the training. So A Limited appealed on the basis that it felt that the effectiveness of the training should not be the sole criterion for assessing its reasonableness. Now, the EAT looked at a number of similar cases and said that the likely effectiveness of a step is relevant to considering whether steps have been taken that are reasonable and whether or not further steps are required. So it's not, what they're saying essentially is that it's not sufficient merely to ask whether there has been training, but consideration should be given to the nature of the training and the extent to which it's likely to be effective. So, for example, if the harassment took place after the training, then it provides some evidence that the quality of the training was poor, and particularly, as in this case, if it wasn't only the perpetrator who didn't understand it, but it was also his colleagues who failed to report it and act upon it. So in this case, the EAT rejected A Limited's argument that effectiveness should not be the sole criterion. The provision had to be considered with regard to the purpose within the equality legislation, which is, of course, to encourage employers to take significant and effective action to combat discrimination. So while it made clear that the defence is available, it is quite a high threshold. And it's only if an employer can show that it took all reasonable steps to prevent harassment that it will successfully be able to rely on that statutory defence. What the EAT did also say in this case was that it would have been preferable had the employment tribunal made more detailed findings about the kind of content or the effectiveness of the training that A Limited put in place. But it was fair enough for the tribunal to have concluded that it was stale. And there was sufficient evidence for them to say that whatever training there had been, it was no longer effective because the training had faded from the memories of the perpetrator and his two colleagues who failed to report it. So coming out of that case, it's not a particularly staggering decision, but I think it is a really useful reminder to employers to consider what policies and training they have in place in relation to harassment, bullying, equal opportunities, discrimination, and all those sorts of discrimination-related topics. The burden is on the employer to establish the defence. So absolutely, the burden is imperative to ensure that all those policies are in place. And as this case points out, that they are of a high standard. The less effective that training is, the more quickly it will become stale as a result, and the more likely you're going to have a finding, as in the Galen case, and not be able to rely on that statutory defence. So it is a huge incentive to minimise your possible exposure to vicarious liability and the actions of your staff. So think very carefully about what sort of training you offer your staff, either at the induction stage or going further and refreshing it during the course of their employment as time ticks along. I suppose you would want to think whether a couple of slides as part of an induction training is really sufficient, or whether actually it merits some external training, some workshops, some forums to discuss those issues. Because what is clear is that the higher quality of training, the more likely it's going to be retained by your staff, and therefore the greater chance of you being able to rely on it. I've had a couple of recent experiences in tribunal claims of thinking about statutory defence. A recent one was a claim for race discrimination in the Employment Tribunal, and we were acting for the respondent, and regrettably their equality and diversity and bullying and harassment training was limited to a couple of slides in an induction training session and a booklet. And really, when it came to the tribunal itself, we made the decision not to even argue the statutory defence because we felt it would be bound to fail. The Galen case had just been published, so the judge was well aware of it. And so in the end, we didn't put forward that statutory defence. I hasten to add we haven't had the judgment in that matter yet, so it remains to be seen what the result of that is. The second recent experience, and something that some employers may have to consider in the future, is when a discrimination claim is issued against them. Sometimes former employees will name specific colleagues, so employees of the respondent, as having perpetrated acts of discrimination. Now, those respondents, they are also respondents to the claim, have the option to take their own legal advice. Quite often, employers will offer to support them and submit a response on their part. But one important thing that a respondent would need to consider in that situation is if they intend to distance themselves from the acts of their employees by arguing the statutory defence, because that's essentially what you are doing by arguing the statutory defence. You're saying they should not have committed this act because we put measures in place to try and prevent it. So it's worthwhile thinking whether or not, if you want to submit a response on behalf of those respondents and support them, you can't really then rely on the statutory defence, which seeks to put a wedge between you and their actions. So it's just something worth thinking about should that matter ever arise, because it will affect your ability to combat that vicarious liability for their actions. So that's really what I wanted to talk about in relation to that case. It's a bit of a reminder of the statutory defence and what sorts of things you might want to put in place to ensure that you are best positioned to defend any liability for the actions of your employees. I'll hand over now to Neha. Thank you.
Thank you, Natalie, and good morning, everyone. So I will start off by talking about the various reforms the UK government is proposing to make to the flexible working regime. Now, the government published a consultation paper called Making Flexible Working a Default. This was published in September this year. The paper sets out 5 proposals for change to the current framework of flexible working. So first of all, the consultation is seeking views on whether the right to request flexible working should be a day one right. So essentially, this would remove the requirement to have 26 weeks continuous service before you're able to make a request for flexible working. So from day one, an employee could, for example, request to reduce their hours to work part-time, or they could, for example, request to change their start or finish times. Secondly, as we know, there are 8 business grounds on which an employer can refuse a flexible working request, and these are all set out in the existing regulations. Now, the consultation is seeking views on whether these 8 business grounds are still considered reasonable and whether any changes are required. Now, in this regard, I should mention that based on what I've read, the government is not expecting to make any fundamental changes to the list of reasons, although some smaller changes may be considered. And thirdly, the consultation is seeking views on whether employers should be required to show that they have considered alternatives to arrangements suggested by the employee when rejecting a request for flexible working. So currently, there isn't any obligation as such on employers to make alternative suggestions to employees, but I think this change is being proposed to sort of encourage a discussion around more around what is possible rather than focusing on what is not possible. Now, The fourth point is that the consultation is seeking views on changing the administrative process required for flexible working. So essentially, currently, employees can make one flexible working request every 12 months, but they're seeking views on whether employees should be allowed to make more than one statutory request a year. And currently, employers have a 3-month period in which they should respond to the employees' flexible working requests, and they're seeking views again on whether this remains reasonable and whether any changes are needed in this respect. Last point being that under the current regime, employees can request a temporary change to their working arrangement, but I think the government sort of realized that this is very underutilized and not very widely known. And for this reason, the consultation is seeking also views on ways in which to raise awareness of this right to request sort of a temporary change to your working arrangement. It is sort of important to note that these proposals are not intended to make flexible working an automatic right. So instead, these measures sort of intend to broaden the scope of flexible working. And it's quite clear that the government wants to encourage communication between employers and employees as to how to balance work requirements and the employees' individual needs. The consultation is due to close on the 1st of December this year, and we will have to wait what the outcome of that is going to be. Now, it is actually not surprising that flexible working has come under the government's radar. Generally, over the last decade or so, employees have started thinking more and more about how they want to work, when they want to work, and from where they want to work. And this sort of trend has certainly accelerated during the pandemic. And during the pandemic, we have seen employees have been working from home. And as you can imagine, as employees start returning to the office, employers are likely to see an increase in the requests for flexible working. Although I should mention that majority of the requests for flexible working that we still see are connected to childcare responsibilities. More specifically, they are often made by women who are returning to work following maternity leave. And for this reason, one of the biggest risk factors for employers refusing a request for flexible working remains claims for indirect sex discrimination. Now, in this context, one recent case I should mention is the case of Mrs. Thompson versus Manners. Now, in this case, the claimant successfully brought a claim for indirect sex discrimination against the employer. So looking at the facts, the employer called Manners is a small estate agency with around 10 employees. And in May 2018, Mrs. Thompson informed the employer that she is pregnant, and she subsequently went on maternity leave. Now, following her return to work, she found that she was obviously had these new caring responsibilities, and for this reason, she applied for flexible working. So prior to the maternity leave, Mrs. Thompson worked 5 days a week from 9 a.m. to 6 p.m. But as part of the flexible working request, she suggested working 4 days a week, and she also suggested finishing work earlier at 5 p.m., which would then allow her to pick her child up from nursery, which closed at 6 p.m. The employer, having received this request for flexible working, held only a 9-minute face-to-face meeting with Mrs. Thompson, following which the flexible working request was refused. Now, this was conveyed to Mrs. Thompson by way of a very short letter, and the basis of the refusal was given, which was based on various business grounds. And these business grounds included the burden of additional cost, planned structural change, and perhaps one which the tribunal considered most significant, the detrimental effect on ability to meet customer demand. Now, following the refusal, the claimant resigned from her employment and she brought various claims. And the ET concluded in this case that the requirement placed on the employees to work full-time did put Mrs. Thompson at a disadvantage. Now, the ET then considered whether the requirement to work full-time hours could be justified. And although the tribunal recognized some of the employer's business concerns, it found that Mannes had failed to show that the refusal of the proposed reduction in hours was proportionate to the needs of the business. And for this reason, Mrs. Thompson's claims for indirect sex discrimination was successful, although I should mention that she brought various other claims which were dismissed by the tribunal. Now, Mrs. Thompson was awarded almost £185,000 in compensation, and this was actually very widely reported in the media. Now, moving on to another interesting recent case, which is the case of Bayfield and Jenna versus Wenderman Thompson. Now, in this case, the tribunal found that the employer had adopted an overly aggressive approach to eliminating gender pay gap. And the claimants, Mr. Bayfield and Mr. Jenna, succeeded in their claims for unfair dismissal, direct sex discrimination, and victimization. Now, looking at the facts, the employers, so Wenderman Thompson's, gender pay gap report was published on around April 2018, and it showed a median gender pay gap of 44.7%, which is quite high. The employers' report described these numbers as very disappointing, and the report went on to say that they were determined to improve these figures in the coming years. That the report also stated that there was, quote, a problem with female representation in creative. A majority of the senior jobs in that department were being held by men. Now, in May 2018, this was following the publication of the report, two senior members of staff conducted a presentation on the gender pay gap issue, and it was brought up in the presentation that the employer had over the years built a reputation as what they called a Knightsbridge boys club, and that the mean and median gender pay gap figures were horrible and embarrassing. Now, more controversially during this presentation, Mr. Bayfield and Mr. Jenner said that they heard in the presentation that it was said that they wanted to obliterate their reputation for being, quote, white privileged British men. Now, after this presentation, Mr. Bayfield and Mr. Jenner, both British and heterosexual and in their 50s, made complaints about the presentation. And they held meetings, which led to very angry responses, to say the least. And in their own words, tensions were running very high. Now, shortly after this incident, the employer undertook a redundancy exercise within the creative department, and Mr. Bayfield and Mr. Jenner were subsequently made redundant, and they both brought claims in the ET. Now, the tribunal found that the employer's desire to take action and reduce its gender pay gap was a perfectly normal response to the pay gap issue. However, they did recognize that the way they dealt with this was quite aggressive. And it also found that the tribunal, And it also found the tribunal that the reason for the dismissal of the claimants was their sex. The tribunal established that the significant factor in the respondents' mind was the gender pay gap issue, and that the reason for dismissing the claimants was that there was an impact. So first of all, in terms of assisting with the gender pay gap figures, and second of all, in that two senior positions would then open up, which could then be filled by women. The tribunal also found that hypothetical female comparators would have not been treated in the same way. Now, as I mentioned before, in the end, Mr. Jenner and Mr. Bayfield's claims for unfair dismissal, direct sex discrimination, and victimization were upheld. Perhaps this case is a good reminder that if an organization is taking action to address the gender pay gap issues, and they should be cautious in that process to avoid any discrimination claims under the Equality Act. That's all from me. Thank you very much. And I will hand over to Natalie now, and I think we'll be fielding some questions.
There we go. Sorry, it was on mute. Thank you, Neha. We are happy to field questions. There aren't any in the Q&A section at the moment. So if you've got a very quick question and you want to type it out very quickly, then please do feel free to do so. I think we will be circulating a brief summary of this meeting and a recording so that anyone who's missed it can see it. And of course, we are always available on emails to answer any of your questions. So please do get in touch. On that note, I don't think there are any questions. So I think we will leave it there. That's 10:20. I think that timing is pretty good. It leaves you the majority of the day. Thank you very much again for joining us, and we hope we will hear from you again in December. Oh, there's something from, no, I think that's just a thank you from Michelle. Thank you. Yes, we'll hopefully talk to you all again in December, and in the meantime, you know where we are. Thanks very much, everyone. Bye-bye.